Welcome to the next episode of Small Business Legal Tips. I'm attorney Mark Brossa Brossa LLC. I'm a Massachusetts business and contract lawyer with over 15 years of experience helping consultants and entrepreneurs build strong legal foundations for their businesses. Today, we're diving into 8 essential contract clauses that every consulting business contract should include. If you're a consultant, whether you work in marketing, management, IT, coaching, or any other type of consulting, your contract is one of the most powerful tools you have to protect your income, manage client expectations, and reduce legal risk. The 8 clauses I'll talk about today are the exact clauses I review and draft for my clients every single week. And by the end of this episode, you'll know exactly what they do, why they matter, and how to adopt them for your own agreements. And please, if you'd like to get more helpful legal tips, please hit the like and subscribe button. It really helps the channel and lets me know that you'd like to receive more tips like this. So grab a notepad and let's get to it. Let's start with the scope of work clause, sometimes called the services or the deliverables clause. This is the backbone of your consulting agreement. It defines exactly what you're being hired to do by your customers or your clients. Too often, consultants get into trouble because their scope of work clause is vague or open-ended. That's how, quote, just one more thing, end quote, turns into weeks of unpaid work or work that's disputed by your clients. Here's what to include in a solid scope of work clause. Number 1, a clear description of services. The first thing you want to include in your scope of work clause is to outline exactly what's included in the services you're providing. For example, if you're providing strategic marketing planning as part of your consulting services, you want to say something like, quote, consultants will provide strategic marketing planning services, including 2 strategy sessions and a written 90-day marketing plan, end quote. Notice the specificity and detail here. You want to identify exactly how many sessions you're providing to your clients and what the written end product looks like. If you don't provide this much detail, you're potentially running into trouble about whether certain tasks are included or not included in the services you're providing. Number 2, timelines or milestones. The second important thing you want to include as part of your scope of work clause is a due date for when your deliverables are due or when certain milestones will be achieved. That way, it's clear to both you and your clients about when you're expected to be finished, and there will be no misunderstandings about whether you're behind or ahead of schedule. Also, by having the timeline set out clearly in writing, this will keep you on track because you'll know when certain tasks need to be finished. It's a well-known psychological and time management principle that having your goals set out in writing helps you to efficiently achieve your goals and tasks. As a pro tip, the easiest way to have a detailed scope of work clause in your contract is to attach a detailed statement of work as an exhibit or an appendix to your contract, and then reference that exhibit in the scope of work section in your contract. For example, you can say, quote, contractor will provide the services set forth in the statement of work attached here to is Exhibit A, end quote. This provides 3 benefits. First, it allows you to provide a detailed scope of work without making your contract awkward and difficult to read. All the technical requirements for your work are contained in the exhibit, and so you get to include all the necessary details of the work you're performing for your clients. The second benefit is that it makes it easier for you and your clients to add additional work in the future if needed. You won't need to add a whole new contract. You can simply update the statement of work and have it signed by both parties. The third benefit is that it makes it easier to have a form contract for all your clients with the same essential terms for everyone. The only thing that will need to be changed from client to client is a statement of work that's attached to each contract as you provide different services to different clients. The next important clause to include in your consultant contract is a payment terms clause. This clause outlines how you'll be compensated, when payments are due, and what happens if the client doesn't pay. Here's what to cover in a payment terms clause. Number 1, your fee structure. The first thing to cover is your fee structure. Are you billing hourly, per project, or on a retainer? Spell it out clearly. For example, if you're receiving a flat rate for your consultant services, you want to say something like, quote, client agrees to pay consultant a flat fee of $5,000 for services rendered under this agreement, end quote. Number 2, payment schedule. The next point to cover in your payment terms clause is your payment schedule and when you'll be paid for your services. Include any due dates or milestone payments when you want to be paid. For example, if you want to be paid half up front and half upon completion, you'll want to say something like, quote, 50% upon signing, 50% upon delivery of final report, end quote. Number 3, late payment policy. The next point to cover in your payment terms clause is your late payment policy. You should protect yourself as much as possible in case your client doesn't pay on time by specifying that you will charge late fees or interest if payment is late. For example, you can say, quote, payments not received within 10 days of the due date will accrue interest at a rate of 1.5% per month, compounding daily, end quote. One pro tip about your payment terms clause is that you want to avoid vague language like, quote, payment upon completion, end quote. Instead, use specific triggers for when payments are due, like, quote, within 30 days of receipt of invoice, end quote. That clarity will help you enforce your rights if there's ever a dispute. The next important clause to include in your consultant agreement is an intellectual property rights clause, which is sometimes called an ownership of work product clause. As a consultant, you're going to be creating some form of work product for your client, which can be reports, software, data, or all sorts of other things. This clause clarifies who owns the work product you create on behalf of your client, which is usually your client. Here's what to cover in a well-written intellectual property rights clause. Number 1, define the work product. The first and most important part of an intellectual property rights clause is to define the work product that's involved. This is typically a very broad definition and will be something like, quote, all results and proceeds of the services performed by consultant for client under this agreement, end quote, and then proceed to add a whole laundry list of items that are far too numerous to name here. However, it's pretty much everything under the sun, so long as the consultant created it on behalf of the client in the course of providing services to the client under the agreement. Number 2, identify intellectual property involved. The next important part of an intellectual property rights clause is to identify exactly what intellectual property is actually involved. And it should be all the types, such as patents, copyrights, trademarks, trade secrets, confidential and proprietary information, and any other types of intellectual property. Number 3, specify obligations. The next important part of an intellectual property rights clause is to specify your obligations under the agreement, which is that you agree to transfer and assign the ownership of the IP for any work product that you create to your client, and that your client is the sole owner of the IP associated with the work product that you create for them. Number 4, pre-existing IP carve-outs. Another important part of the intellectual property rights clause is that you want to identify carve-outs for your pre-existing IP that might be incorporated into any work product that you create for your clients. It's not uncommon for consultants to incorporate their own IP into any work product. So you want to make it clear that you're not transferring ownership of your pre-existing IP to your client, even though it's been incorporated into the work product you create for them. A pro tip about your intellectual property rights clause is that you want to make sure that the transfer of any intellectual property rights to your client is contingent upon your receipt of full payment from the client for the services that you provide. The way to do this depends on the exact structure of your intellectual property rights clause, and you should speak with an attorney if you're not sure about how to do it. But one way to do it is by adding an introductory clause at the very beginning of the sentence that discusses intellectual property ownership of the work product by stating, quote, upon consultant's receipt of full payment from the client for the services, end quote, which is then followed by the remainder of the sentence discussing IP ownership of the work product. The next important clause to include in your consultant agreement is a confidentiality clause, which is also known as an NDA provision. Consultants often have access to sensitive client data, such as financial information, customer list, marketing strategies, and much, much more. By including a confidentiality clause in your agreement, you'll be building trust with your client and shows them that you are sensitive to their confidential information and that you'll make sure to take steps to protect it. It also protects you because if you share your own proprietary methods or frameworks, you should include mutual confidentiality language to safeguard your intellectual property and your confidential information as well. In my earlier NDA secrets video, I talked in detail about what should be included in your NDA agreement, so I won't go over all that here again. I'll put a link to the video below so you can check it out. An NDA clause isn't really that much different from a full-fledged NDA agreement, and so all the same points apply and should be incorporated into your NDA clause in your consulting agreement. One pro tip about a confidentiality clause is to be very careful about including one in your consulting contract if you are also signing a separate NDA agreement. You don't want conflicting agreements or obligations, so make sure that the language is the same in both agreements and that the protections are the same. Pay particular attention to the choice of law and the choice of forum clause because these dictates where any lawsuits can be brought over any confidentiality issues. The next clause is really probably two separate clauses, but it's all about managing expectations and the promises you make about the quality of services that you'll be providing to your clients. Even if you think that you're going to give your best efforts to each and every client and that your services will definitely solve your client's problems, it's not something you can guarantee, and you don't want to put that in your contract. As you know, the world is complicated and things can always go wrong. Instead, you want to offer a limited warranty to your clients along the following lines. Quote, the consultant represents and warrants that the services will be provided in a professional and workmanlike manner. End quote. Additionally, you also need to include a disclaimer of warranties in order to avoid certain warranties that are implied by law, such as the implied warranty of merchantability, fitness for a particular purpose, or any others. Implied warranties will automatically be applied to every contract unless you specifically disclaim them in writing in your contract. So you want to include something like, quote, except as expressly set forth in this agreement, the services to be purchased under this agreement are furnished as is, where is, with all faults, and without warranty of any kind, express or implied, including without limitation any warranty of merchantability or fitness for any particular purpose. End quote. One pro tip about a limited warranty and disclaimer of warranties clause is that you want to include your disclaimer of warranty in all caps. That way, they are conspicuous and no one can claim that they didn't see them. The next clause to include in your consultant agreement is all about risk management. Even if you do everything right, things can go wrong and a client may claim your advice led to lost profits or a project didn't deliver expected business results. In order to prepare for this, you want to include a limitation of liability and damages clause as part of your consulting agreement, which limits the types of damages you can be responsible for and caps how much you could potentially owe if there's a dispute. So, for example, you could include a clause like, quote, consultant shall not be liable to the client for special, incidental, consequential, or exemplary damages arising out of or relating to the services provided under this agreement, whether based on contract, tort, including negligence, strict liability, or any other theory, even if the consultant has been advised of the possibility of such damages. Consultant's total liability for any claim arising under this agreement or related to the services shall not exceed the total fees paid by the client in the 3 months preceding the event giving rise to any claim. End quote. A clause like this can help protect your business in the event that you ever get sued. One pro tip about the limitation of liability and damages clause is that it should also be in all caps like the limited warranty clause. Also, you should be sure to get professional liability insurance, which is also called errors and omissions insurance. The clause limits your exposure contractually, and the insurance will help cover you in the event a claim ever arises. The combination of the two keeps your business legally and financially protected. The next important clause that every solid consulting contract should have is a term and termination clause, so that it's clear how the agreement can end and what happens when the agreement ends. Here's some topics to cover in connection with your terms and termination clause. 1. Term. The clause should specify how long the parties expect the agreement to last, which is called the term of the agreement. For example, you can say, quote, this agreement shall remain in effect until the services are completed, end quote. Or if you want the agreement to last for a set period of time, you can say, quote, this agreement shall remain in effect for a period of 1 year, end quote. Number 2, termination for convenience. Another issue to address in a term and termination clause is whether either party can terminate the agreement for convenience, which means for any reason at all. You don't have to allow for termination for convenience, but if you do, you should require notice, which is typically 30 days advance notice in writing. Number 3, immediate termination. One critical issue to expressly address in your term and termination clause is your right to immediately terminate the agreement and stop providing services in certain situations. For example, you probably want to have the right to immediately terminate the agreement and stop providing the services if your client doesn't timely pay your invoices or doesn't provide you with the access or materials needed to provide your consulting services. There are a lot of different situations where you might want to have the right to immediately terminate the agreement, so if you're not sure what to include here, you should speak with an attorney. Number 4, payment upon termination. Another critical issue to address in your term and termination clause is how you'll be compensated for the work done by you up to the termination date. For example, you can say, quote, upon termination of the agreement for any reason, client shall pay consultant for any unpaid services performed by consultant up to and through the termination date, end quote. That way you'll be sure to get paid for all the services you provide before the agreement is terminated. Finally, every strong consulting contract should have an integration clause, which is sometimes called a merger clause. This is a clause that states that this written agreement and any exhibits or attachments is the entire agreement between the parties and supersedes all prior discussions and agreements. So for example, you can say, quote, this agreement and attached exhibits sets forth the entire understanding of the parties and supersedes any and all prior agreements, arrangements, and understandings relating to the subject matter hereof, and may not be changed except in writing signed by the parties. No representation, promise, inducement, or statement of intention has been made by either party which is not embodied herein, end quote. The reason why you want to have a clause like this is to prevent scope creep, or claims that you promise to provide additional services that are not specifically identified in the contract. Every important contract should be contained in the contract in the statement of work. And if it's not there, it's irrelevant even if you had discussed it beforehand. As a pro tip, along with the integration clause, make sure to have a process in place for any change orders or modifications to the services provided under the agreement. Any changes should be signed by both parties and should specifically reference that it's amending or adding on to the original agreement. So there you have it. 8 essential clauses every consultant should include in their business contracts. Number 1, scope of work clause. Number 2, payment of terms clause. Number 3, intellectual property rights clause. Number 4, confidentiality clause. Number 5, limited warranty and disclaimer of warranties clause. Number 6, limitation of liability and damages clause. Number 7, termination clause. And number 8, integration clause. With these clauses in place, you'll be protecting your time, income, and reputation while setting clear expectations with your clients. I hope you found this information helpful. If you found it helpful, don't forget to like the video, subscribe to Small Business Legal Tips, and hit the bell so you don't miss future episodes. Thank you so much for watching, and I'll see you in the next one.